And I'll leave is occurring by Zoom with me in my office.
Thank you.
Your Honor, Miranda Bailey Quick on behalf of Mrs. Lilly.
Thank you. So I just heard my staff ask Bailey Quick. I was just double checking as to whether or not your client would be here. We can certainly have a status conference without her present, but apparently you had misunderstood and thought this was only a show cause instead of also a status conference. Is that accurate? So we'll start with the show cause. Ms. Bailey Quick, I explained to the attorney that you had tried to stand in for you. I don't allow attorneys to stand in for other attorneys on a show cause. The show cause hearing is directed at you. And it was directed on me. It was directed at you because, as I explained to blanking on your colleague's name right now, but as I explained to the other attorney, I don't think in 10 years now that I've been on the bench, I've ever show caused an attorney and actually done anything about it. I've never had a fine. I've never had an issue with a failure to appear. Because I recognize, especially in the Zoom age, there are many times where there's multiple hearings scheduled at the same time. And so what I ordinarily do, and what I did in this case, is I set a show cause for you to just give an explanation. And if an attorney gives an explanation as an officer of the court, I have always routinely accepted it. I set this for a show cause, and in what I would describe as completely unacceptable, you decided not to appear at a show cause. And that puts me in a very terrible position, and it put your colleague in a very terrible position to have to be told that I'm not going to let him advocate for you or argue for you. It's your opportunity to show cause. And what he tried to explain is that you had another hearing. I don't think that helped the argument. That seemed to suggest to me that you had a knowing choice and you just simply decided not to appear in a show cause. So I wanted to give you an opportunity on your own to explain it. That's why I ordered you to appear in person, because now this is the third hearing that I've had to schedule because of your non-appearance.
All right, folks, buckle up. This is one of those courtroom moments that makes you question just how chaotic legal scheduling can get. We're in a virtual Zoom hearing, but don't let that fool you. Tensions are already sky high. The judge is calm but firm, making it clear that no attorney can stand in for another at a show cause hearing, which is already rare enough. And here we have Ms. Lilly's attorney, who somehow missed multiple hearings due to medical leave conflicts, electronic calendar mishaps, and scheduling confusion. Stay tuned, because what seems like a simple oversight is about to put everyone in a legal bind, and you'll see just how far the court will go to enforce accountability. This is courtroom drama at its finest.
So what happened at the first hearing, and that was back in
November 1st.
November, thank you. What happened in November?
Your Honor, I originally prepared the stipulation in order, setting it for November 1st, believing that I would be off medical leave by then. Unfortunately, I calendared that on my Harris Law calendar, and about 2.5 weeks after that, they turned off my access to everything electronic while I was on medical leave.
And that's when you left and went on your own soon thereafter?
I am still technically at Harris Law until my medical leave expires, which has been pushed to the middle to end of this month.
So you still don't have access to calendars?
I now have my own calendar, but the original November 1st date was on the Harris Law calendar, and I, by oversight, missed that in adding it to my new calendar.
All right, and then what happened last month?
The morning of, and I can pull it up, but the morning of that date, I had another adjourned trial that, again, I had believed that I would be off medical leave by that point, and I can just pull up the date.
It was December 1st that I had to go.
December 1st. Okay. So that same morning, my client called. I had calendared for December 3rd, 2 days later, a trial in Charlevoix County. My client had called me that morning and inquired about the trial that afternoon. I contacted the court. They confirmed that it was in fact scheduled for that afternoon. And
here's where the tension really starts to rise. The judge is laying down the law about attorney accountability. She's never had to fine an attorney or issue a show cause in over a decade, yet here we are. Non-appearance isn't just inconvenient. It puts colleagues in a tough spot and risks serious consequences. The courtroom dynamic shifts. What might have seemed like a minor scheduling conflict is now a question of professionalism and respect for the court. Notice how the judge emphasizes that this isn't punitive for punishment's sake. It's about maintaining order, transparency, and responsibility in the legal process. You can feel the weight of the expectations in every word.
That put me in a position to really, because it was in person and it was with an incarcerated individual, and that put me in the position of scrambling to try and find coverage because another attorney isn't going to cover a trial.
Well, you also could have just contacted me to see if I'd be willing to adjourn the hearing. You could have contacted Mr. Vernon and asked him if he'd be willing to stipulate to move it to a date that you didn't have a conflict.
I did attempt to call Mr. Vernon, and I left, I believe, 2 separate messages for him, and I believe I emailed. I can't confirm for certain the email, but I did call his office twice.
Why did you not contact my staff?
Honestly, Your Honor, I didn't think without Mr. Vernon's consent that you would entertain that.
Ms. Bailey, quick, conflicts, as I explained already, come up all of the time. That's not new. It's newer and it's harder now with Zoom because you are expected to be in more places than generally before 2020. But I can tell you with 100% certainty that if I got a call from any attorney who explained that they had a conflict in an in-person hearing, I would do one of 2 things. I would either, 1, call the other judge and have a communication about moving both hearings so they could be accommodated, or I'd just move on my own motion a hearing. Because I don't expect you to be at 2 places. But I certainly expect more than lack of communication to my office. I'm the one who ordered you to show cause. And the position you left me in was to decide whether to order you to appear this way in person or to issue a bench warrant. And I don't want to do that because I know what that means for attorneys. And I know the schedule that we keep. But you put me in a terrible position where you could have simply done it differently. My point in bringing this up is I expect it to be done differently because I don't want to have show causes. I don't want to order attorneys to appear in person to have discussions about not appearing at court dates. And if I didn't think there was good cause.
Now, we get the attorney's side of the story, and it's messy. She was on medical leave, lost electronic access to her calendar, and the November 1st hearing slipped through the cracks. It's a very human explanation. Medical leave and tech glitches are relatable, but in court, the rules don't bend easily. The judge isn't dismissing her reason, but she's making it clear, oversight isn't enough when people are relying on you to show up. And notice the subtle tension. She tried to cover her bases with another attorney, but as we learned earlier, that won't fly in a show cause. This is a fascinating clash of human error and legal procedure.
I do. There's good cause in the sense that you had a conflict. You didn't handle it, in my estimation, correctly. If I have that type of activity again, I'm not going to look at just having a discussion about it. This is simple notification to the court. And that's what I expect, is if you have a conflict, you notify me. And that's what the court rules require, is if you have a conflict, you immediately bring it up to each court that you have a conflict with. So read those rules if you haven't before, follow them in the future. Do you have any questions about what I've said so far?
I don't. I understand the court's position, and I want you to know it wasn't intentional or deliberate or just trying to be disrespectful. I understand the court's position now, and I, at the moment, with a very little bit of time, thought I was doing the right thing by finding coverage. So I again apologize. I now understand the court's position and what should be done.
All right. Mr. Vernon, did you wish to offer any oral statements for purpose of the review of the record for the show cause matter?
No.
In terms of status conference, then, Mr. Vernon, as plaintiff's counsel, where are you at in this case? I know there were some discovery issues and I issued an order. Do you have the discovery you need? Are you still working to receive that? Where are we at?
So we received what I believe are the answers to their discovery. We received them about noon today. So I haven't had the opportunity to review them with my client. It does appear that the discovery has been provided. So I think they are in compliance with their discovery demands.
This is a textbook moment on how courts handle conflicts in the Zoom era. The judge is explaining something crucial. Conflicts happen, that's fine, but lack of communication is a problem. She's very clear that attorneys must notify the court immediately if they face scheduling issues. With Zoom, it's easy to be in multiple places at once, but accountability hasn't disappeared. This part of the hearing is a masterclass in professional responsibility. The judge is firm but fair, acknowledging good cause while pointing out procedural missteps. And for the audience, this is a great peek behind the curtain of how courts maintain order even in complex, modern schedules.
I don't know where that puts us other than, we're still reviewing it.
All right. You don't have anything outstanding as far as you're concerned, though.
I'm sorry?
You don't have any outstanding requests that have not been, I know you haven't gone through them in detail.
No, it appears that all the questions we sent over have been answered. I don't know if they've been answered fully, but it appears just by flipping through that there's an answer in each category.
So, Ms. Bailey Quick, I know you weren't expecting this to be a status conference, but just from your standpoint, do you believe you've supplied all of the outstanding discovery that's been requested?
I brought a copy with me today. On December 15th, I did provide everything but the signature from my client, who I got, I believe, a day or two later. And I provided all 244 pages to Mr. Vernon on December 15th. So
All right.
I believe it has been complied with.
Are you awaiting discovery? In other words, I'm trying to get a sense of when I should set a next status conference and what I need to do to facilitate the parties working towards either resolution or knowing that you need to be prepared for trial.
I have not requested of Mr. Vernon more fully or complete answers or documentation because my client wants to get this case resolved. We left off with whether or not we were going to go back to mediation. That is where I believe we're at. I provided Mr. Vernon with the parties' oral agreement from back in, I believe they had the conversation early within the first quarter of 2025. I provided that quite some time ago, long before December, to Mr. Vernon. My client's position hasn't changed, and I just need to know at this point whether we're going to continue mediation or if we're just...
Shifting gears to discovery, the lifeblood of pretrial preparation. Here, we see the attorney providing 244 pages of documents to Mr. Vernon and the judge carefully verifying compliance. This isn't just paperwork, it's critical for ensuring both sides have what they need to argue the case fairly. Notice the judge's methodical questioning, making sure no outstanding requests are overlooked, and the attorney's effort to demonstrate due diligence. It's a slower, technical part of the hearing, but vital. It shows the courtroom's commitment to process and transparency and gives us a glimpse into the often unseen grind behind every trial.
We just need to set the matter for trial.
Well, did you start mediation and then pause it to get more information, or did you just complete it and it wasn't successful?
At that point, Mr. Vernon asked for more information.
Mr. Vernon, is that accurate in terms of at the mediation? You started it, you didn't continue and finish because you wanted to get the discovery that maybe was subject to that last motion?
Yes, the parties were pretty far apart at that point, so we just said there wasn't any real point moving forward until we got additional information. I think the expectation was that once we got it, we would return to mediation.
All right. Well, who were you using as a mediator? Were you just doing the facility or the
Community
community
mediation.
dispute resolution services? I'm going to order that you return to that mediation. I don't have a problem, Mr. Vernon, if you tell me you need a little bit of time to go through the discovery, if it was 244 pages before you do that. But given your representation that that's already what the plan was, do you have any reason to oppose that?
I do not.
Do you, Ms. Bailey Quick?
I do.
You do?
No, I do not.
Oh, all right. So I'll order that. How long do you need to return to the mediation then and decide whether or not you have a possibility of resolution or whether or not the court needs to just calendar for trial?
I would defer to Mr. Vernon. I'm ready to go.